All right, good afternoon. I'm not seeing Mr. Howell.
I will text him. He'll be on in just a minute. I think there might have been some tech issues.
Your Honor, I'm here. Sorry for that.
Good. Let's go ahead and get everybody in and get started. I'm going to take the pleas first. I'm going to take some out of order, and then we'll get to our status reports. All right, good afternoon, everyone. This is our status calendar. We also have a couple of pleas. So counsel, I'm going to ask for your indulgence. You don't have a plea today. I've got 3 pleas to take first, and then we'll get into the rest of the status calendar. The first case I have for a plea is Anthony Platt. Is Mr. Platt on?
Your Honor, I believe he may be running a little bit late. If we could take his plea at the end of the calendar.
All right, I'll set that one aside. How about Jonathan Britton?
Here.
Here. All right. Let's hear from Ms. Dufford on the terms of the plea.
Yes, Your Honor, this is case 19 CR 006230F. The defendant was charged with simple battery, family violence, and reckless conduct for an incident that occurred on July 28th, 2019. The defendant is pleading, I'm not sure, Mr. Howell, if he's pleading guilty or nolo.
He is pleading, he's offering a plea of guilty.
I apologize for that. The defendant is pleading guilty to the simple battery, family violence. The state has submitted a proposed order to null pros the reckless conduct charge. The terms of the negotiated or plea is 12 months probation to complete an approved family violence intervention program and to have no further violent or harassing contact with Sierra, Sierra Robinson. The balance shall suspend upon successful completion of the family violence intervention program and no further violent or harassing contact with the victim.
Right.
Your Honor, that is our understanding of the plea agreement.
All right. Ms. Daniels, do you have the null pros on that, or have I already signed that?
She just sent it, Judge. She sent the 2 null process for a second case as well.
All right. Right. Mr. Britton, I have a couple of questions for you.
Yes, sir.
Britton, you're being represented by attorney David Howell here today. Is that correct?
Yes, sir.
You satisfied with the services?
Yes, sir.
Before I consider your plea, do you have any questions for Mr. Howell about this plea or this case?
No, sir.
All right. And you are pleading guilty today to simple battery, family violence. Is that correct?
Yes, sir.
And you understand that by pleading guilty to that charge, you're giving up the right to a trial.
Yes, sir.
Right. Can you adjust your camera so I can see your face, sir? Thank you.
Do you see me?
Got some background noise there.
Sir.
Britton, you understand that part of the conditions. Now, Mr. Britton, I can't see your face. Got to see your face. I don't want to take your plea.
No, I gotta hold my phone to my ear because my speaker messed up. So I gotta hold it to my ear. My speaker messed up.
All right, you can hold it while you're listening, but when you're talking, I got to see your face.
All right.
All right, so, Mr. Britton, you
Sir.
understand that that the recommended sentence requires you to take 24 weeks of family violence intervention program classes. You understand that?
Yes, sir.
Right. You understand that if you don't report to probation, if you don't attend those classes, that I can revoke your probation and put you in jail.
Yes, sir.
All right. Accept your plea. Sentence is as recommended. No further violent contact with the victim in this case, Ms. Robinson. We have that contact. We'll go to jail. Now, from here, Mr. Britton, what's going to happen is you're going to get contacted by probation. That contact may be through your cell phone. So until you've got contact with probation, don't ignore any cell phone calls that you get from strange numbers. You can answer all calls until you connect with probation and know how and when you're supposed to report. Otherwise, that would be a violation of your probation terms. You understand?
Yes, sir.
All right. All right, I think we have everything we need. Unless you have any more questions, Mr. Britton, you're free to go.
No, sir.
All right, you're free to go. Thank you, sir.
All right.
Your Honor, if you would allow it, the state would like to make an announcement while we have all the private attorneys on right now about office hours that we're currently having in our office every Thursday. If you'll allow me to make that announcement.
Go ahead.
Thank you, Your Honor. So for all the attorneys, public defenders, private attorneys, we're starting a new thing in the Solicitor General's office where we'll be having office hours via Zoom from 3 p.m. to 4:30 p.m. every Thursday. If you would like that Zoom link at any point in the future, just you can shoot me or Stephanie an email for Judge Richardson's cases. Thank you.
Right. Next plea I have is Lawrence McMillan.
Your Honor, David Howell representing the defendant.
All right, and I see Mr. McMillan is here. Hear from the state regarding the terms of the plea.
Yes, Your Honor. This is case 21 CR 000326F. Defendant was charged with battery with an incident date of January 28th, 2021. He's pleading guilty to the battery charge, and the state's recommendation is 12 months probation to complete a 12-week anger management course and to have no further violent or harassing contact with Keniya, K-E-N-I-Y-A, Wright, and the balance shall suspend upon successful completion of the anger management course.
All right, what
I have a question, Judge, before you go further. On the sheet that I'm looking at, we're talking about Mr. McMillan.
That is correct. The original charge was battery, substantial physical harm. The state did amend that accusation to a battery charge.
Oh, no, that's not what I'm referring to, Ms. Duffer. On the plea sheet, it says no further contact. So is this no further contact or no further violent contact?
I apologize. I misspoke. It is no further contact with
Okay.
Keniya Wright.
Right.
Your Honor, that is our understanding of the plea agreement. We'd ask that you accept it as the state has recommended.
All right, Mr. McMillan, I have a couple of questions for you. Can you hear me, sir? Mr. McMillan, can you hear me? I'm not getting a response from Mr. McMillan. All right, we'll have to come back to Mr. McMillan. All right, let's go through our status calendar. Position 1, Thomas Jones.
Your Honor, David Howell representing Mr. Jones. Mr. Jones is not here today. I am here on his behalf. He has the funds to pay the alleged victim in this. As you may recall, the state has agreed to dismiss the charges once he has paid the alleged victim back for the car, which was allegedly stolen. The issue we've been working through with the state is how to get the funds to the alleged victim. What we have worked out is that within the next 6 weeks, my client will consult with the sheriff's department and go to the alleged victim's address, retrieve the car, and provide the funds. We put it on the client that if this is not done by the next court date, which we're hoping for 60 days out, that it will get added to a trial calendar.
Yeah, this is pretty much the same report that we got at the last status conference. So, yeah, we're not going to reset it. Status is going to be reset for trial. But if it's paid, if it's paid before then we won't have to go forward. I'll just look for that dismissal.
Thank you.
Unless someone tells me otherwise, unless somebody tells me it has to be otherwise, everything I'm setting down for trial is going to be bench. So somebody has to tell me if it has to be a jury trial.
Your Honor, we would request a jury trial.
All right, that one's ready for jury. Position 2, Carrie Williams.
Your Honor, the state submitted a null pros in this matter.
Right. Position 3, Darlene Whitaker.
Good afternoon, Judge. Dennis Murphy.
Good afternoon, Mr. Murphy.
I was recently appointed. I have filed my entry and motion for discovery. Hadn't gotten discovery back just yet. In addition, Judge, I have reached out to my client several times. No call back yet. So I was just hoping if you can just get me to another status calendar, and then I'll report as soon as I know something from her.
All right, we'll give you one more reset to try and establish contact. I believe they're heading up to the last status conference. Nobody had any contact with defendant in this case, so.
Yeah, so perhaps, yeah, if she's MIA, I'll run an address and see where it takes me. I appreciate the courtesy, Judge. That's all I have for today.
All right, you may be excused. Thank you, Murphy.
Thank you, Mr. Daniels. Bye.
All right, Mr. Britton sent a message asking if he could be excused. Yes, Britton, you may be excused. All right, position 4, Carnell Elliott.
Good afternoon, Judge. How are you doing?
Very good. How are you, Mr. Sullivan?
Good. At the last status conference, I sent the state paperwork regarding some competency matters with Mr. Elliott. Ms. Salet's supervisor reviewed that and wanted something more. So I've been in contact with the solicitor's office. We've agreed on an evaluator, a psychological evaluator, to do the competency. Mr. Carnell Elliott's wife is scheduling an appointment to have that done. And however they rule on his competency, I'm fine with it. If they deem him competent, then we'll enter a plea. If otherwise, then we'll have another resolution in the case.
All right. We'll reset that. Another status in the next 60 days.
Thank you, Judge. We should have that wrapped up well in advance of that, I think.
All right.
Thank you. That concludes my business. May I be excused?
You may be excused.
Good to see you, Judge.
Thank you. All right, position 5, DeAncis Bailey.
Your Honor, David Howell representing Mr. Bailey. Mr. Bailey is currently incarcerated in Clayton County. He is interested in taking a plea. We aren't able to do that today due to his incarceration, but we do hope to do that via plea abstention as soon as the case in Clayton is adjudicated.
All right, do we have any kind of time frame on
I have tried to reach out to his public defender in Clayton County. I've not heard anything back, but he believes that the case will be adjudicated within the next 3 months.
We'll reset that one.
Will it be status or plea calendar?
Status. All right, position 6, Gilbert Farnsworth.
Good afternoon, Your Honor. David Gaddis for Mr. Farnsworth. we were on this calendar prior, there is a similar case that's being reviewed by the district attorney's office. They have not moved forward or backward on that matter yet. I've spoken with the state and we've provided some information regarding the therapy and everything else this family's going through now. I think the state and I agree that if we could get one more continuance for the next status conference to see what the district attorneys are going to do, they'll either pull this case up or I guess kick it back, the other one down, or not prosecute it.
All right, we'll reset that for status one more time.
Thank you, Your Honor. That's all I have today. May I be excused?
You may be excused.
Thank you, sir.
Position 7, Kimberly Smith.
Your Honor, I did reach out to Ms. Smith's attorney. I'm not sure if he is on this afternoon, on June 14th, just to confirm that he had all discovery and what the status was in this case, and have not heard back.
Right. We'll follow up after this calendar on that one. Position 8 was a plea. Position 9, Stephen White.
Yes, Your Honor. Oh, there goes Mr. McNally there. I see him.
Good morning, Your Honor.
How are you, Mr. McNally?
I'm doing well, sir. How are you?
Good. All right, so let's talk about the status. Do we have y'all had any discussions?
Yes, Your Honor. So the defense just filed a motion. So I would just ask that this case be placed on a motions calendar. And in between that time, we can still continue our discussions.
Your Honor, so I did just file a motion here today, but there were several motions filed back in March. There is a motion to compel, and I've talked to Miss it's Satellite, right? Satellite. So I've talked to Miss Satellite, and it looks like there might be some very new information. There are some videos that exist in the case. I've also filed a motion for leave to file a speedy, constitutional speedy, and also an immunity motion. And all of those were filed back in March, Your Honor. Then I just filed something today, which is a motion to suppress a statement. So, I mean, we definitely do have some motions we need to hear. I would prefer to get all of the evidence and take a look at it and just have all of our motions on one date. I'm worried if we set a motions date, I might get a bunch of discovery, that week before, and then have to rush around, review it, and try and crank some motions out before the motions date. But there is some outstanding discovery in this situation.
All right, we're going to set it for motions. We'll give you 60 days to complete any necessary discovery. Then we'll put it on a motion calendar 60 days out. You'll get further notice.
So, Judge, you're saying 60 days from today to resolve discovery or make sure we've got discovery, and then 60 days from there, a motions date?
60 days from today, the earliest possible motion date.
Okay.
We don't have a precise date to give you today, but it won't be any sooner than 60 days.
Yes, sir. And I will continue to work with Ms. Satellite on that discovery.
All right. If and if there's a discovery issue that we need to resolve at that point, then we can use that time to resolve it.
Yes, sir.
And sounds like with the nature of the motion, we probably need to be in person for that.
I would prefer to do it in person, Your Honor, if that's available.
We'll
I
do-
understand maybe jury trials are coming back in September. Is that word? That's what I hear. I don't know.
There's some limited stuff going on now, but criminal for me, we may be starting in September.
Excellent.
All right, we can handle motions in person.
Great.
All right, thank you, Mr. McNally.
Excellent. Good to see you, sir. Thank you. Thanks, Ms. Sadlett.
Thank you.
All right, next I have position 10, Brian McClendon.
Good afternoon, Judge. This is Renee. How you doing?
Very good. How are you?
And Judge, I think what we're going to do is just stand by our not guilty plea, request that it go to a jury trial calendar. And my hopes is that we can work it out prior to that. And Judge, I do have one more person on the calendar that I'm going to ask for another status on, but Judge Barry wants me to sign in front of her in DeKalb County. Can I just let Ms. Dufford make that announcement?
Which case is that?
I'm sorry, I don't know why I'm looking at too many people. That's on Michael Conlon, Judge. I just need another status because we kind of thought we were going to divert that, but she's reviewing all my conversations with the office. I also think there might be some body cam evidence. So unless you want me to just get another 60 days for all the discovery and get on a motions calendar, either way is fine if you want me to keep it moving. But I think at the end of the day, we should be able to resolve it.
It's between position 20, Judge.
That's correct. Conlon is position 20. This is the first time it's been on a status calendar. Discovery was filed on June 16th. I did forward that to Ms. Rockwell. We have had conversations about this. I'm hopeful that we are able to resolve it, but I am reviewing the file regarding a possible diversion resolution.
We'll give it one more reset. Hopefully y'all can resolve it in the meantime.
Thank you, Judge.
10,
Can you
what are
give me
we
that
doing,
date?
Judge, before Ms. Rockwell leaves? Position 10? What is
Oh,
it being
McClendon,
reset
that
to?
was
That's going
further
to,
notice to jury.
Reset jury? Okay.
Right.
all right, thank you, Ms. Rockwell. You are excused.
Thank you so much, Judge, for letting me break the line. Appreciate it. Y'all stay safe. Thank you, Judge.
All right, position 11, Roger Budd.
Mr. Weiner has a leave of absence.
Position 12, Rodney Fulmore.
And Your Honor, this case was approved for diversion. So I don't know how, I'm not sure what calendar you put diversion cases on, Your Honor.
Position 13, Timothy Caraway.
Good afternoon, Your Honor. I'm here on behalf of Mr. Caraway.
Yes, Your Honor. We have filed discovery on this case and given an offer. I've been in communication with Mr. Schwartz. We are still waiting on some labs from GBI. One lab in particular did come back, but the other one said it won't be ready until July 10th. And based on that lab, it's possible that we could be sending this case to Superior Court. So I would ask for a reset for another status calendar, Your Honor.
All right, Mr. Schwartz, anything to add?
No, Your Honor.
We'll reset it one more time for status.
Thank you, Your Honor. May I be excused?
May be excused.
Thank you.
Position 14, Chelsea Cloud.
Yes, Your Honor, I represent Ms. Oates Gould. And I would ask that this case be placed on a plea calendar.
Plea calendar?
Yes, please.
All right. Get that on. All right, 15, Christopher Wolstein? Or Wolstein?
Your Honor, this is a possible diversion case, and I believe his attorney, Mr. Hernan, had reached out to Ms. Daniels, and they were excused from appearing today.
All right, position 16, Andrew Hightower.
Good afternoon, Judge Mike Pugliese for Mr. Hightower. Ms. Duffert and I have been in talks on this case. I think we're very close to tweaking out a plea. I believe, Ms. Duffert, we're going to run one issue concerning first offender in a limited probationary period, completing the anger 8-week anger management requirement of the sentence. Is that correct?
That's correct, Your Honor. I still, as opposing counsel stated, there are some things we needed to tweak out, so we're not quite there yet. But the one question we had regarding first offender was if it was necessary for the defendant to be on for a full year if he took first offender. The court requires that if he completes the other terms.
We were asking for is to terminate probation when he completes the terms, which is the 8-week anger management class, Judge, to conclude it. I know the law only says you need, I understand what the court may require, and that's what we just want to clear up.
Let me look at, I'm going to set it down for plea calendar. Let me look at, let me look at the statute one more time, just to make sure I have the discretion I need. If I have the discretion, I'm willing to let it conclude over, but I may not have that discretion. So let me look at.
I can get it for you, Judge, but I appreciate it.
All right, we'll put it down for a plea.
Thank you, Ms. Duffert. Am I excused, Judge?
May be excused.
Thank you, sir.
And Your Honor, the victim has appeared on the Zoom as well. May she be excused? I will reach out to her to talk with her after the hearing as well.
All right. Position 17, Fadarian Crawford.
Your Honor, David Howell representing Mr. Crawford. Mr. Crawford actually has two cases. One is already in our courtroom. One has been transferred or is in the process of getting transferred by Ms. Daniels from Judge Besson's courtroom. The state has filed a motion to revoke bond in this matter due to the second case. We are waiting on body-worn footage, cam footage, as well as the 911 call in this case. We've received initial discovery, and as soon as we get the rest of the discovery, we're going to engage in plea discussions with the state to see if we can get this resolved.
What I'm going to do is I'm going to put this on a motion in the next 45 days. Hopefully you can get it resolved before then. Otherwise, I'll hear the motion to revoke.
Good morning.
Mr. Crawford, I spoke on your behalf. I'll be reaching out to you later today so we can talk about what transpired and how we proceed forward.
All right. Hope you guys are.
All right, Mr. Crawford, you're free to go.
All right. Nice to see you.
Thank you, Mr. Crawford. Take care. All right, position 18, Quima Windless.
Kenya Bryan on behalf of Mr. Windless.
And Your Honor, I actually just submitted a null pros to Ms. Daniels for the case against Quima Windless.
All right, we'll resolve that, and y'all are free to go.
I have 3 more, Judge, so I'll hang tight.
All right, what's your next one? Let me see.
Position number 21, Brandon Jordan.
All right.
And Your Honor, this matter, the state did file discovery on June 16th. I did email the discovery to Ms. Bryant. We have had email correspondence regarding this matter, including I did send her a recommendation, I believe this morning or yesterday afternoon.
That's correct, Judge. So I have discovery as well as an offer. My client at this point is not prepared to accept the offer. This may end up on a trial calendar, but we like to have an opportunity to continue to negotiate with the state.
All right, is this a matter that can be a bench trial, or does it have to be a jury trial?
Judge, I think he would prefer a jury trial.
We're gonna set it down for a jury. That could be a ways away. So if you're able to resolve it in the meantime, just let Ms. Daniels know and we'll get it on a plea calendar.
I sure will, Judge. Thank you.
All right. And you have another one? Yep. Number 22, Chase Hawkins.
Yes, Judge.
Your Honor, this the same announcement. Discovery was filed on June 16th. Emailed copies to Ms. Bryant, as well as a recommendation, state's recommendation in this matter.
That's correct. Your Honor, I would need to present the offer to my client. I have not been able to present it to him as of yet. And so I would like an opportunity to have him scheduled for another status calendar so that we can decide what we're going to do. But I have everything I need. I just need to get my client to approve the offer that has been extended.
All right. When did you receive the offer?
I believe was it this week?
That's correct. I did send it this week, and discovery was emailed on the 16th. So my apology is that I didn't send the offer with the discovery. But Ms. Bryant did email me back that she was going to reach out to Mr. Hawkins regarding that recommendation.
That's correct, Judge.
Else I'm looking.
One
more, 34.
30. Yes, Judge.
Ray Price.
Yes, Judge. I have received, I think we'll say it's the state.
Your Honor, we have filed discovery on this case, presented an offer, and I believe Ms. Bryant does have the video as well. So I would ask that this case we're ready for trial on this case, Your Honor.
Yes, Judge, we agree to that. We just need to get the video to play so that we can see exactly there. And once we see it, we'll be in contact with the state to determine what our next move would be. But for right now, we'll just ask that the court put it on a jury calendar. Jury trial.
That'll be set for jury trial. All right.
Thank you. That completes my business. May I be excused?
You may be excused.
Thank you. Have a good day.
Thank you. I'm going to come back to Mr. McMillan. Let's go to 24, Hunter Duran.
Hi, Judge. Eric Bernstein on Mr. Rand's behalf.
Afternoon, Mr. Bernstein.
And Your Honor, this matter, discovery was emailed on June 16th. I have had several conversations with Mr. Bernstein. We are awaiting some outstanding discovery that we've reached out to Roswell PD and are still awaiting supplemental reports to provide to opposing counsel. And based on that outstanding discovery, there may be a resolution to this matter that we won't need a trial or anything further on. I'm hoping to have that resolution within the next couple weeks or upon receiving that supplemental discovery from Roswell.
We'll reset that next status conference.
Do you have that date you're on, or do we just wait for that?
Just wait for notice on that one. We don't have a date on that one yet.
Okay,
Right,
can we be excused, please?
you may be excused.
Okay, take care.
Right, position 25, Sammy Dinkins.
Anna, this is my case. I have received all of the discovery for this case, and I did receive an updated offer. I need to relay that to Mr. Dinkins so I can get an announcement for the court whether this will be a plea or a motion.
So you anticipate motions if there is not a plea?
If there is not a resolution, then it will be a motion.
What we'll do is we'll set it down on a motion calendar. And obviously, if you can resolve it before then, we'll take a plea, or we can take a plea on the motions date.
Okay.
You have the paperwork ready.
But this be in person or Zoom?
In person.
All right, position 26, Jesus Garcia.
Good afternoon, Judge. I'm Haley Hudler here on behalf of Mr. Garcia. I'm Mr. Sperling from my firm is the attorney of record for this case.
And Your Honor, the state did file discovery in this matter on June 16th this year. I did email the discovery to Mr. Sperling, as well as it was mailed from our office. I have not heard anything from opposing counsel regarding this case.
And Judge, I can confirm that we did receive the discovery that Attorney Defford emailed to Mr. Sperling, and we have had a chance to review that. The paper discovery that was sent to us does mention that there was dash cam and body cam footage, but we haven't received any of that video footage. And so we wanted to check on the status of that with the state.
That information can be provided to your office. It's just that I needed to be contacted that there were outstanding discovery issues in that respect. And since I had not heard from anyone, that was not sent. That's not typically something that our office would straight send to opposing counsel upon sending discovery, just the notification that it is available for your office to receive. This is the first time it has been on a status calendar, Your Honor.
We'll reset it to the next status calendar.
Thank you, Judge. And Attorney Defford, I'll make sure that either Mr. Sperling or another attorney from our office reaches out to you in regards to the video.
Thank you very much. Appreciate it.
All right.
And Judge, that is my only case on the calendar. So at this time, may I please be excused?
You may be excused. Thank you, Ms.
Thank you.
Position 27, Yamoko Wiggins.
Sorry, Judge. Good afternoon. Show Watson for Ms. Wiggins. She is not present on this call. I spoke with Ms. Dufford yesterday, and Ms. Dufford, let me know if I'm speaking out of turn here, but we just like to have this reset to the next status calendar, give us an opportunity to possibly resolve this matter.
That's correct, Your Honor. Discovery was filed in this matter on June 16th, and I did email the same to Mr. Watson. I just need, upon the conversation that we had, I need to review the case for a possible resolution.
Give you one more reset. See if you can work it out.
Thank you, Judge.
Judge, before Mr. Watson leaves, Mr. Watson, are you going to accept the appointment that I sent you, the email the other day? This is Mrs. Daniels.
Oh, do you mind resending it, Ms. Daniels? Because I looked back through my email and I didn't see it. Let me give you my email address again, if you don't mind.
Okay.
It's SDW, S is in Sam, D is in dog, W at Show Watson, SHOWATSON is in Nancy.com. So SDW at showwatson.com.
All right. Thank you, sir.
Thank you, ma'am. I appreciate it. Judge, may I be excused?
Be excused. Thank you, Mr. Watson.
Thanks, sir. All right.
Position 28, Tamisha Dixon.
I represent Ms. Dixon, and this is similar to my last case. This will either be a plea or a motion. I'm just looking into a couple more legal issues to see if it is a good motion. The law is more confusing than I thought that it would be. But if it's not, then it will be a negotiated plea.
So you have not already filed the motion, but you're considering filing a motion.
Correct, Judge. The state has given me an offer in the case. There might be a legal issue that I am researching. If I believe that there is, I'll file a motion. If not, then we will do a negotiated plea. Sorry, I thought that this would be more straightforward than it is, and it's more confusing than I anticipated when I looked into it.
All right, we'll give you one reset.
Thank you.
Hopefully we can get it resolved.
Thank you.
Position 29, Tyrell Bivens.
I represent Mr. Bivens. I have the discovery from the state. Mr. Bivens was actually recently shot multiple times and is on a lot of pain medicine. I've provided medical documents to the state. I don't feel comfortable with him making any legal decisions right now due to the medication that he's taking. So I would ask for a reset for him. Like I said, the state has given me an offer and all discovery.
That'll be reset. All right, position 30, Meshach Johnson.
This is also my case. The state has provided me with discovery. The state has also submitted a motion to revoke bond. So I would request that that motion be in person. Right now, the offer is 12 months to serve, so I don't see that resolving prior to the motion.
We'll reset that to motions.
And I think I said I would be asking that everyone be in person for that.
Position 31, Joseph Ross.
Afternoon, Judge. Judy Kim for Joseph Ross.
Afternoon, Ms. Kim.
Judge, we're still waiting, I believe, for body cam footage. Not sure if the state has been able to get that or not at this point.
I sent you a link via Dropbox and it says you had received it. Did you receive that?
I thought that was just the discovery. I've been tied up. I'll take a look at it today and reach out. I called you earlier, but I assumed you were in court. So should we hopefully reconvene tomorrow if you're available?
That's fine with me.
Okay.
But the state would say that we're ready for trial, but I'll leave it to the court's discretion, Your Honor.
All right. I'm going to put this as ready for trial. Obviously, if you can resolve it before we reach you, I'm happy to take a plea. Ms. Kim, can this be a bench trial?
Yes, Judge.
The state have an objection?
I don't have an objection to a bench trial, Your Honor.
All right. I'll be ready for bench. Position 32. Ms. Kim, you're excused. Position 32, Alistair Murray.
Your Honor, David Howell representing the defendant. We've entered into negotiations with the state. We haven't been able to come to an agreement yet. The state is looking through their case file to see if the simple battery family violence was dropped or not. We had received an indication it may have been. They are checking on that. And we are waiting on body cam footage and I believe the 911 call on this tape. And since we would like to request a jury trial on this.
That's correct, Your Honor. Discovery was filed on June 16th and emailed to Mr. Howell. This is the first time it's been on a status calendar. We have ordered the 911 and the body worn camera, and we'll provide that once it is received. And we are reviewing the file regarding a piece of information that was provided to the state today in regards to that simple battery family violence charge.
All right. Put it on the jury calendar, but obviously I'd like to encourage y'all to keep talking, see if y'all can resolve it beforehand, because it may be some time before we can get it up for jury trial. All right, position. We've come back around. Position 33 is Mr. Anthony Platt. I believe Mr. Platt is on now. I think we are ready to take that plea.
Yes, Your Honor.
So that we got the 20. And then we've got a 21. So let's go ahead with the plea on the 20. And we'll talk about the 21.
Yes, Your Honor. This is case 20 CR 004512F. The defendant was originally charged with battery family violence and 2 counts of cruelty to children in the third. The state has amended that accusation to add a simple battery family violence and has submitted a null pros for the battery family violence charge and the 2 counts of cruelty in the third. I just emailed those to Ms. Daniels prior to court. The state's recommendation in this matter is 12 months probation to complete an approved family violence intervention program and no drugs or alcohol, and to have no further violent or harassing contact with the victim in this matter, whose name is Sherkita Platt, and that's SHERKITA. She is on the line this afternoon. I'm not sure if she wanted to give a statement or not. In case 21 CR 000804F, the defendant was charged with simple battery. He is pleading guilty to that charge. In this case is to run consecutive with the 20 CR 004512F case. No drugs or alcohol, and to have no further violent or harassing contact with Sherkita Platt.
All right.
Your Honor, that is our understanding of the plea agreement. We'd ask that you go along with the state's recommendation in this case. And just to clarify, Ms. Dufford, you did say no violent or harmful contact, correct?
I said no violent or harassing, but no violent. Okay. In that respect, no violent or harassing contact with Sherkita Platt.
Very good. Just wanted to clarify.
And Judge, before you take the plea on the null pros, it has 2 cruelty to children charges. There is only 1 cruelty to children charge in Odyssey.
If I could have 1 second to review, I pulled the information. I thought that there were 2 charges of cruelty in that case. If not, I will amend and resend the null pros with just the 1 count. But the state's intention was to null pros the battery family violence and the cruelty, and that he would be pleading guilty to a simple battery family violence that was amended to add that charge.
Right. I believe we have victim advocate on. Does Ms. Platt wish to be heard?
Hello.
Hello, Ms. Platt. Anything?
Yes.
You're entitled to be heard before I consider the plea and the sentence that's recommended. Is there anything that you wish to say?
From this point, I can actually say that he has done better with himself as to this point.
This is good to hear. You're supportive of the terms of his probation. Take
Yes.
the Family Violent Intervention Program, no drugs and alcohol. So you support those terms?
Yes.
All right, very good. Thank you, Ms. Platt.
Thank you.
All right, Ms. Platt, I have some questions for you.
Yes, sir.
All right, you are being represented by Attorney David Howell today, is that correct?
Yes.
Are you satisfied with his services?
Yes. Super.
All right, and you're pleading guilty today to simple battery family violence, is that right?
Yes.
And you understand that by pleading guilty to that charge, you're giving up the right to a trial.
Yes.
So the recommended sentence here is that you go on probation, and as a condition of you being on that probation, you have to take 24 weeks of family violence intervention classes, have no drugs or alcohol, and no violence or harassing contact with Ms. Platt. You understand all those conditions?
Yes.
And you understand that if you don't comply with all those conditions or report to probation as directed, I'll revoke your probation and put you in jail. You understand that?
Yes.
All right. I accept your plea. The sentence is as recommended. Once all conditions are satisfied, probation can go to non-reporting status. Mr. Platt, we have contact information for you that we're going to give to probation. Probation's going to reach out to you. They're most likely to reach out to you by phone. So over the next few weeks, don't ignore or block any strange phone calls until you've made contact with probation. If you don't touch base with probation, that'll be considered a violation and you could wind up in jail. So just make sure that you get in touch with them and follow their instructions as to how and when to report. You have any questions, Mr. Platt, before we let you go?
No.
Judge, can you tell me what we're doing on his second case, position 33?
Oh, yes, we have one more case. Thank you, Ms. Daniels. All right.
I can't hear you.
We have one more case. That's the 21 case. What is the status on that one?
Your Honor, I apologize. I thought I'd given both recommendations. That matter is to run consecutive with the 20 case and no drugs or alcohol, and to have no violent or harassing contact with Shakita Platt.
Okay, I don't have any plea paperwork for position 33.
It was all sent over in one packet.
And as a follow-up to the cruelty issue, that was an oversight on my part. I did correct the null pros order and resubmit it to Ms. Daniels and copied Mr. Howell on it.
Yes, Ms. Daniels, I'm looking at the file that was sent over, and it looks like it is a total of 5 pages, 4 of which are the plea paperwork, and then 1 page, which is the probation contact form.
And David, what date was that?
Look. June, it was Tuesday.
Tuesday? Give me one moment.
Ms. Winless, you sent a message. Is it okay for you to leave? Yes, your case has been dismissed, so you are free to go. I apologize for that.
Ms. Daniels, I just resent it, send it
Okay,
again.
because I'm not able to pull it up.
I just re-forwarded it to you.
Okay, so you said this is to run concurrent? Or
Run
consecutive?
consecutive.
Consecutive?
Yes, ma'am.
Judge, I have it.
All right, Mr. Flat, let's talk about case number 21 CR 0000804. You understand in that case, you've been charged with simple battery, family violence?
Yes.
Powell's representing you in that case as well, is that correct?
Yes.
You're satisfied with his services?
Super yes.
All right, and you're pleading guilty to that charge today?
Yes.
Do you have any concerns or doubts about pleading guilty to that charge as well?
Mr. Platt, if you want, we can go into a breakout room and discuss.
I'd rather go to the breakout room.
I'm sorry, I didn't hear.
He'd like to be put into a breakout room so we can discuss.
All right. Get to move on.
Mr. Platt, just click on the little box that appeared on your screen where it says join breakout room.
All right.
All right, while we're waiting for one. Mr. Stein, I see you waiting. Which case are you here on?
Yes, Your Honor, it's Andrew Vaz, V-A-Z.
All right, let's talk about status on that one.
Yes, Your Honor. The state has provided all discovery and an offer to Mr. Stein. He did mention possibly filing a motion, or I don't know if he's already filed the motion. So I don't know if he wants this to be placed on a motions calendar, but the state's ready for trial.
Stein, you want a motion? You want to go directly to trial? What's your pleasure?
Yes, I've had some productive discussions with Ms. Salette earlier today, about 45 minutes ago, and we both talked about putting this on a motions calendar with the eye on getting it resolved, but we definitely would need to have it on the motions calendar. We have a clear-cut Elliott issue on this case, Judge.
We'll reset it to motions calendar. Do we need to have it in person, or is this a legal issue we can deal with by Zoom?
I think Zoom will work, Judge, and I suspect the state might consent to it ultimately, so. Consent to the issue itself that's being presented.
All right, we'll reset it to motions calendar.
Shall I wait for notice to be sent in the future?
Yes, sir.
Very well.
And
Good
is
seeing you,
this-
Judge.
Is this over Zoom or in person?
It can be over Zoom. All right. All right, thank you, Mr. Stein.
All right, good seeing you, Judge. Thank you.
All right, and 35, Robert Benz.
The attorney has to leave.
All right, I think Mr. Platt and Mr. Howell are back.
Yes.
All right, Mr. Howell, you're on mute.
Sorry about that. We would like to proceed with the plea. Just one clarification. Though the sentence runs consecutive, if the court could just affirm that it's only one family violence intervention program, you don't have to take two back to back.
That state's understanding?
I apologize. Yes. The recommendation was just one family violence intervention program.
All right, but consecutive. So practically it means it's going to be non-reporting after he's finished the 24 weeks. Although the full term is 2 years, it will be non-reporting for the balance. All right, Mr. Platt. Are you, and so coming back to our case, number 21 CR 0000804F. You are pleading guilty to the charge of simple battery family violence?
Yes.
All right. And you understand that by pleading guilty to that charge, you're giving up the right to a trial?
Yes.
So you understand that if you don't complete all the terms of that's already been outlined in your previous case, you'll be violating this probation as well?
Yes.
All right. Well, I expect, I have no doubt that you'll complete the terms and resolve both of these cases and move on with your life. So I accept your plea.
I
Sentence.
just want to get back home, Judge.
I'm sorry?
I just want to get back home to my family. My bad.
Yes, sir. All right, so you're going to get a call from probation, like I told you before. Well, head up the probation for both of these cases. Just make sure you stay in touch with probation and get to work on the family violence intervention program classes. And
okay.
Stay clean.
Thank you.
Thank you, Mr. Platt. You are excused.
Thank you.
I think we've taken care of everybody except Mr. McMillan.
Yes, Your Honor.
All right, we can hear you now and you can hear us. All right, so we've got a plea.
I apologize. I'm at work. That's why you probably couldn't hear me before.
All right, Mr. McMillan, let's go ahead and hear again the terms.
Sorry about that. This is case 21 CR 0000326F. The defendant was originally charged with battery, substantial physical harm. The state has amended that charge to a battery charge. And the recommendation is 12 months probation, to complete an approved 12-week anger management course, to have no further contact with Keniya Wright, and that's Keniya, and the balance shall suspend upon successful completion of the anger management course.
All right. And Mr. Howell, those are in accordance with the terms negotiated?
Your Honor, that is our agreement we have with the state. We would ask that you go along with it.
Mr. Dillon, I have some questions for you. You're being represented by Attorney Howell here today. Are you satisfied with his services?
Yes, sir. Very satisfied.
All right. Do you have any questions about this case or your plea before I consider your plea today?
No, sir. Wait, yes, I do. Okay, so probation, that's virtual, right?
It can be virtual. Reporting can be virtual. Absolutely. I believe
Yes,
it.
because I have a
Classes I think they are virtual right now, but I can't tell you for sure.
yes, because I have a job and that's going to cut up my hours and my rent, and I'm on Section 8.
Mr. McMillan, if you want, we can talk about this afterwards. What I believe the client is worried about is that reporting to probation will interfere with his job, potentially leading to lost income. What I've relayed to him is that the last thing probation wants to do is take somebody who is gainfully employed in the community, and interfere with that.
And the
So they
same
will-
with the anger management.
So as long as you're reporting to probation, as directed and working with them to get on a schedule to get this done, you'll be fine.
Oh, I'm good. I ain't no runner. I report. I'm gonna report because I don't need that on my background. I need to keep my job, my family, my housing, my Section 8. I'm doing good at the predicament I'm in around. I'm doing good, and I'm proud of myself. So I'm not trying to jeopardize myself by running or nothing like that.
As long as you're making a good effort, we're not going to kick you off probation or put you in jail because you might have a work conflict.
Understandable.
So just keep in touch with them. Work and make arrangements, and
yes.
Be any issues.
Okay.
Any other,
when will they?
Any other questions?
When will they be calling me?
Well, it can be anytime. We're going to take your plea here today. After we take your plea, we're going to give your contact information to probation, and they're probably going to reach out to you by phone. So I'm going to tell you to be on the lookout for strange numbers on your phone. Don't block them. Don't send them directly to voicemail and ignore them. Just make sure that you get in touch, that you're able to get in touch with them and they're able to get in touch with you.
Okay. Okay, and you said 12 months, and after 12 months, within 12 months, after I complete the anger management, the probation is over with, right?
As soon as you're done with the anger management class, probation is over.
Okay.
So you have 12 months to do it, but it's only 12 weeks of anger management. So, your probation could be done in 3 months if you're.
All right.
4 months if you get started right away.
Okay. Understandable.
All right. Any other questions?
No, sir.
All right. So you are pleading guilty today to the charge of battery. Is that correct?
Yes.
All right. You understand that by pleading guilty, you're giving up the right to a trial.
Yes.
All right. Accept your plea. The sentence is as recommended. Once probation is verified that all conditions have been satisfied, probation will terminate.
Okay.
Mr. McMillan, you are free to go today.
Yeah, have a nice day.
You too.
Thank you.
All right, I see Attorney Rowe here.
Yes, sir. I'm here.
And Mr. Amin?
Judge, I'm not sure if he was able to get on. I know he is
I'm here.
not. Oh,
I'm
you
here.
are? Okay.
Yes.
Okay, good. But never mind what I was getting ready to say. We're here, Judge. Our announcement is we're ready for jury trial. I did receive discovery from the state, and right now our announcement is ready for trial.
All right. Are you or your client willing to consider a bench trial, or you need to have a jury?
Now we need a jury on this, Judge.
All right. Put it down for a jury trial.
And the state is ready as well.
All right, very good. All right, thank you.
Thank you.
Mr. Rowe and Mr. Amin, y'all are free to go.
Okay.
Thank you, Judge.
Thank you.
Take care.
All right. That, any further business?
No, Your Honor.
No, Your Honor.
All right, hearing none. Thank you, everyone. Everybody have a great rest of the week.
Thank
Thank
you.
you.
Thank you, Judge.